This is the moment the First Lady's financial life stopped being private and became federal evidence. Not through a leak, not through an investigation that took years to surface, through a judge's order, signed at 8:31 this morning, that directed the immediate asset freeze and seizure of $34 million held across 3 offshore accounts in the names of entities that federal prosecutors allege are beneficially owned by Serena Hale, wife of President Victor Hale. If you looked at the U.S. District Court for the Southern District of New York right now, you would see a building that has processed more significant financial cases than any courthouse in the country, and is nonetheless operating this morning with the particular energy of an institution that knows it is handling something it has never handled before. The clerks know, the marshals know, every attorney in the building who has seen the docket entry that appeared at 8:47 this morning knows. Because the docket entry contains 3 words that have never appeared together in this combination in the history of American federal jurisprudence: First Lady, seizure. President Victor Hale already managing the fallout from his niece's book, a Senate oversight process that has consumed 3 of his senior advisors' full attention for 7 weeks, and an approval rating that has not risen above 31% in 4 months, has just had the ground shift again in a way that is entirely separate from every previous challenge and potentially more damaging than all of them combined. Because previous challenges have been about what the president did or said or decided. This one is about money, specific money, $34 million, in offshore accounts, in entities whose beneficial ownership federal prosecutors say they can prove connects directly to the woman who lives in the White House. As of this hour, the accounts are frozen. The seizure order is active. Serena Hale's personal attorney issued a statement at 9:15 a.m. saying the order will be challenged and the accounts have been misidentified. The judge who signed the order has not withdrawn it. And somewhere in the Southern District's evidence processing system, the financial records that convinced a federal judge to sign that order this morning are being cataloged and numbered. In this breakdown, we are going to show you exactly what the government's asset seizure motion alleges and what the $34 million documented trail looks like. We are going to walk you through how offshore accounts in the names of foreign registered entities get connected to a specific individual through the mechanisms federal prosecutors use, and why that connection was apparently strong enough to satisfy a federal judge. We are going to show you what the seizure order means for the White House's legal and political position, and how it interacts with everything else currently in motion against this administration. And we are going to explain why what happened at 8:31 this morning is not the end of a process. It is the visible surface of one that has been running quietly for much longer. The accounts are frozen. The money is in federal custody, and the First Lady's name is on a seizure order. 16 years ago, before Victor Hale had declared his first candidacy for any office, before the Hale name carried its current political weight, and before the scrutiny that accompanies proximity to federal power became a feature of daily life, Serena Hale's financial advisors established a series of holding structures in 3 offshore jurisdictions. The structures were not unusual in form. Wealthy individuals use offshore holding entities for a range of purposes that are entirely legal: tax efficiency, estate planning, asset protection, business investment management. The use of such structures is common enough among high net worth individuals that their mere existence carries no presumption of wrongdoing. What makes the structures at the center of this morning's seizure order different from the thousands of similar arrangements that exist without federal consequence is, according to the government's motion, a combination of factors that individually might each be explainable, but together form a pattern that federal prosecutors describe as consistent with concealment of assets from federal disclosure requirements. Serena Hale, as the spouse of a federal official and subsequently the First Lady, has been subject to financial disclosure obligations under federal ethics laws that require the reporting of assets above certain thresholds. The government's motion alleges that the 3 offshore entities whose accounts were frozen this morning were not disclosed in any of the financial disclosure filings submitted by the Hale family during the period of Victor Hale's public service. The motion further alleges that the entities were restructured 3 times during that period in ways that the government describes as consistent with the deliberate maintenance of beneficial ownership while minimizing the documentary trail that would connect Serena Hale directly to the accounts. The combined balance across the 3 accounts at the time of the freeze order was $34 million. The money did not arrive in those accounts all at once. It accumulated over 12 years through a series of transfers that the government's forensic accountants say they have traced to their sources. What those sources are is not fully disclosed in the public-facing portions of the seizure motion. What is disclosed is that at least a portion of the funds move through financial systems that trigger specific federal reporting requirements that the government alleges were not met. He gambled that structures established before his political career carried significant weight would remain below the threshold of scrutiny that his public role attracted. He assumed that the complexity of the offshore arrangements was sufficient protection against the kind of sustained forensic investigation that would be necessary to connect the entities to his wife. He assumed that the people who established and managed those structures had built them to withstand exactly that kind of investigation. He assumed wrong. And the assumption cost $34 million its freedom this morning. At 6:14 this morning, a sealed motion was filed with the duty judge of the Southern District of New York, requesting an emergency asset freeze and seizure order on 3 accounts held at financial institutions in 2 offshore jurisdictions. The motion was classified as a civil asset forfeiture proceeding under the federal money laundering statutes, which allows for asset freezes without a prior criminal conviction, when the government can demonstrate probable cause that the assets are connected to specified unlawful activity. The probable cause standard is lower than the standard required for criminal charges. It requires the government to show that it is more likely than not that the assets are connected to the alleged activity. The duty judge reviewed the motion and its supporting documentation for 2 hours and 17 minutes. At 8:31 a.m., she signed the order. The time between filing and signing is significant. 2 hours and 17 minutes is not a judge who was uncertain or required additional materials. It is a judge who read a motion with substantial evidentiary support and concluded that the standard was met. The motion was not returned for supplementation. It was not accompanied by a request for oral argument. It was signed. At 8:47 a.m., the order was docketed and simultaneously transmitted to the financial institutions holding the accounts. Under the terms of the order, those institutions were required to freeze the accounts immediately upon receipt and confirm compliance to the court within 2 hours. Both institutions confirmed compliance by 10:30 a.m. Pause. The accounts were frozen before most of Washington had processed the morning news. By the time the first network morning program broke the story at 9:22 a.m., $34 million had already been inaccessible for 51 minutes. While the financial institutions were confirming compliance, Serena Hale's personal attorney was on the phone with the Southern District Prosecutor's Office, attempting to understand the scope of the motion and determine what documentation had been submitted to support it. Sources say the attorney was told that the supporting materials were under seal and that formal disclosure would occur through standard discovery proceedings once the case progressed. The attorney's statement issued at 9:15 a.m., describing the accounts as misidentified, was released without the attorney having seen the government's evidentiary basis. While the attorney was operating without full information, the White House counsel's office was receiving a separate briefing from its own contacts within the Justice Department. That briefing, according to sources familiar with its content, was described afterward by one recipient as more detailed than we wanted it to be. The White House counsel's office has been in continuous session since 9 a.m. And while the White House was absorbing the briefing, the financial press was processing what a First Lady asset seizure order means for the broader perception of the Hale administration's integrity. The implications for the administration's ability to function politically, legislatively, and diplomatically were being assessed simultaneously in editorial meetings, trading desks, and foreign ministry offices across 3 continents. By 11 a.m., the U.S. dollar index had declined 0.8% against a basket of currencies. Political risk premium on U.S. sovereign instruments moved for the 3rd time this month. The market is not making a judgment about guilt or innocence. It is making a judgment about institutional stability. And this morning's judgment was not favorable. According to sources with knowledge of the investigation that produced this morning's seizure motion, the government's forensic accounting work on the offshore structures dates back 22 months. The investigation did not begin with Serena Hale as its primary subject. It began as a broader financial crimes inquiry that identified the offshore entities through a network analysis of transactions flagged by the Financial Crimes Enforcement Network's automated monitoring systems. We have learned from 2 people familiar with the investigation's development that the connection between the offshore entities and Serena Hale was not established through a single document or a single transaction. It was established through a pattern of correspondence, financial transfers, and structural changes that the government's analysis says cumulatively demonstrates beneficial ownership beyond the threshold required for the civil forfeiture standard. The 3 restructurings that the government's motion references, each of which occurred during the period of Victor Hale's public service, were conducted by a financial advisory firm that also maintains relationships with several other individuals currently under federal scrutiny for unrelated matters. The overlap in advisors is not, by itself, evidence of wrongdoing. It is, however, the kind of connection that federal investigators described as a thread. This morning's seizure order is what you get when 22 months of pulling on that thread produces enough material to satisfy a federal judge. A senior financial crimes attorney not connected to the case described the civil forfeiture mechanism being used this morning as a tool that prosecutors reach for when they want to secure assets before a criminal case is ready to file. Their words, "A seizure order is not a verdict, but it is a statement. It is the government saying in a signed judicial document that it has probable cause." That is not nothing. That is a lot. The question now facing the White House legal team is not whether to challenge the order. They will challenge it. The question is how to challenge it without the discovery process that a challenge initiates, producing a more comprehensive view of the offshore structure than the current sealed motion contains. Why does this seizure order matter beyond its immediate financial and legal dimensions? follow the disclosure obligations. The federal financial disclosure system for senior government officials and their spouses exists for a single purpose: to allow the public and its elected representatives to assess whether the people exercising federal power have financial interests that could conflict with the public interest they are supposed to serve. When those disclosures are accurate and complete, the system works. When they are not, the gap between what was disclosed and what actually exists is not just a legal violation. It is a statement about the relationship between a public official and the obligations of public service. If the government's motion is correct that the offshore entities holding $34 million were not disclosed in the Hale family's federal filings, then the gap between what was disclosed and what existed is not a rounding error or an administrative oversight. It is $34 million in offshore accounts for 12 years through 3 restructurings during a period of federal service. The power dynamics in this situation have shifted in a way that is structurally different from the political challenges this administration has faced before. Previous challenges involved policy disagreements, personnel controversies, and documented conduct that could be argued about. This challenge involves a judge's signed order, frozen accounts, and a probable cause determination made by a federal official with no political accountability to either party. The administration's political machinery cannot reach into the Southern District's evidence processing system. It cannot change what the forensic accountants found. It can challenge the legal interpretation. It cannot challenge the bank records. The congressional dimension activates on 2 tracks simultaneously. The Senate Finance Committee has oversight jurisdiction over financial disclosure compliance by executive branch officials. The Senate Judiciary Committee has oversight over the Justice Department's conduct of the investigation. Both committees will have received formal requests for hearings by the end of today. Whether leadership schedules those hearings depends on a political calculation that is being made right now by senators who are all reading the same docket entry and drawing their own conclusions about what it means for their positions. Here is the pressure structure as it now exists and how it compounds what was already in motion. The Diana Hale book publishes tomorrow with documentation of financial conduct within the Hale family going back 32 years. The seizure order issued this morning involves financial structures established 16 years ago. The 14-month New York State Attorney General inquiry that declined to comment on the book excerpt yesterday is now in possession of a federal probable cause determination about offshore financial structures that may or may not overlap with the scope of the state inquiry. 3 separate financial investigations operating across 3 separate jurisdictions have each produced significant public developments within the past 72 hours. They are not the same investigation. They do not need to be. Their simultaneous visibility creates a picture of a family whose financial life, examined from multiple directions by multiple authorities, keeps producing the same category of finding: structures that were not disclosed, transactions that were not reported, and arrangements whose complexity appears calibrated to the distance they create between the beneficial owner and the documented record. Foreign governments that maintain intelligence assessments of American political leadership are updating those assessments today with a data point that changes their calculations about leverage, vulnerability, and the reliability of the Hale administration as a negotiating partner. A First Lady whose offshore millions are subject to a federal seizure order is not a peripheral detail in those calculations. She is the president's closest personal relationship. What she is exposed to, he is exposed to, by proximity, by disclosure obligation and by the political reality that a president whose household finances are under active federal investigation is a president operating at a significant disadvantage in every context where credibility is the currency. The administration's legislative agenda, which has 3 significant items pending in the Senate, is now competing for floor time and political attention with a story that every senator's staff will be asked about at every constituent meeting and every press availability for the foreseeable future. The senators who were willing to negotiate with the White House on those items last week are now running a different calculation about the cost of visible association with an administration whose First Lady is the subject of a seizure order. Inside the White House tonight, sources describe a building that has moved past the eruption of this morning into the specific stillness that comes when the people responsible for managing a situation have concluded that the tools available to them are inadequate to the situation they are managing. The communications team cannot explain the accounts because explaining them requires acknowledging they exist. The legal team cannot challenge the order without initiating a discovery process whose outcomes they cannot predict. The political team cannot change the story because the story is a signed judicial document. The president has been on calls with his personal legal counsel for 6 of the past 8 hours. His public schedule for tomorrow has not been released. The First Lady has not made a public appearance since Sunday. The offshore account is not just a financial structure. It is the distance between the public version of a life and the private one. Every element of its design, the offshore jurisdiction, the entity structure, the beneficial ownership separation, the 3 restructurings during the period of federal service, was a choice made to maintain that distance. Not because the people making those choices were necessarily doing something wrong, because they wanted the distance, because they believed the distance was permanent. Federal forensic accountants have a single professional purpose: closing that distance. 22 months of work produced a motion that satisfied a federal judge in 2 hours and 17 minutes. The distance that was supposed to be permanent turned out to have a paper trail. Paper trails end in courthouses. This one ended in the Southern District of New York at 8:31 this morning. You can structure an offshore entity to separate your name from your assets, but you cannot separate your name from the correspondence, the transfers, and the structural decisions that the people managing those entities generate and retain. You can restructure 3 times to minimize the documentary trail, but each restructuring is itself a document. You can operate for 12 years inside a structure designed to be invisible, but 22 months of sustained forensic attention is longer than most invisibility lasts. So where are we tonight? Serena Hale's attorney is preparing a motion to challenge an order they have not yet fully seen the evidentiary basis for. The accounts are frozen and the money is inaccessible. The White House counsel's office is in continuous session with no public statement ready. The Diana Hale book publishes tomorrow. The New York State Attorney General's office is not commenting. The Senate Finance Committee will receive a formal hearing request before midnight. And the $34 million that was in 3 offshore accounts this morning is now in federal custody under a probable cause determination signed by a judge who took 2 hours and 17 minutes to decide the standard was met. Watch for 3 things as this develops. First, whether Serena Hale's legal team files a challenge before the end of the week, and what specific ground they challenge on, because the ground they choose tells you what they believe is their strongest defense, and by implication, what they believe is weakest. Second, whether the Justice Department's investigation that produced the civil forfeiture motion is accompanied by any parallel criminal referral to a grand jury, because a civil forfeiture and a criminal grand jury running simultaneously represent a qualitatively different legal exposure than either one alone. Third, whether any sitting senator makes a statement that references both the book and the seizure order in the same breath, because that statement from a member of the president's own party would signal that the political protection that has sustained this administration through previous challenges is reaching its structural limit. The distance is closed. The accounts are frozen. The paper trail is in federal custody. And the version of the Hale family's financial life that was designed to remain invisible just became the most discussed document in Washington. Watch closely. We will be back when the challenge is filed or the grand jury meets, whichever comes first.